This, I think, is the first merged webinar we've ever done. So it's obviously me from One Chancery Lane and Rob from 9 Golf Chambers. I don't think there's anyone left in the legal world who doesn't know that we're merging. Not Rob and me personally, we're both married to other people very happily. But we are, as Chambers, merging in, I think October is going to be the launch. So you'll all be invited to the launch party, obviously. And yeah, this is our first run at giving a merged webinar, so bear with us. I think most of you know me. I specialise in cross-border and travel work. A lot of you, I think, will also know Rob. He's a specialist in PI and in clinical negligence, but also does some cross-border stuff. And he actually wrote the book on clinical negligence, very excitingly. So if you've got any questions about clinical negligence, I feel sure that Rob would be delighted to answer those today as well.
As a point of information, I edited the book, which effectively means I got my bright colleagues to write it, and I merely justified it on both sides.
Too modest, too modest. And of course, is listed in the Legal 500. I feel I should get that in just for extra embarrassment. Oh, and while I'm plugging books, Sageston on Travel Law has hit the warehouse and will be released over the summer. So all rush out and buy your copies of Sageston on Travel Law. Reasonably priced at only £145, available from all good bookshops. Right, now that I've done my plugging, which I know that Emma would want me to do, I'm going to answer the first question that's appeared in the Q&A, and then we will get on. So, from an anonymous attendee, I have an odd situation in which the MIB has accepted a Part 36 orally and paid the settlement sum, but never received written acceptance despite strenuous chasing. Is there an implied acceptance in such situations? Well, they've accepted it, haven't they? But they've not accepted it within the bounds of Part 36. I don't think I know the answer to that question. Do you know the answer, Rob?
Let me just clarify this. The question is, it was a call-to-bank offer or a Part 36 offer that was made and then accepted?
It was a Part 36 offer that was made, so it would have been written when it was made, but it was orally accepted, so it wasn't accepted in writing. So it's a Part 36 offer, but not a Part 36 acceptance. Is there an implied acceptance in such situations? Well, I think if I go back to my contractual days, there's an acceptance of an offer on Part 36 terms. So I think the answer to that is it's not a Part 36 offer and acceptance, but it is an acceptance of an offer which would then incorporate the terms that fall within Part 36. But that's my intuitive answer. It may not be the answer.
I think I might make a different view. I'm just thinking back to offers to treat and the cases such as that. So a shop offers to sell you a razor for £4.99. You then go to the till. You're the one that actually makes the offer, and then the cashier accepts your offer at that price. So when things are wrongly labelled up, the shop doesn't do out. Here we've got an offer, clearly a Part 36 offer. The purported acceptance doesn't quite match it. But if they've said, no, we accept the offer you've made, I'm wondering when, if you then responded to go, brilliant, we're all agreed at settlement at this, it's a similar analogy. You're absolutely right. I've got it here, 3611. You can only accept a Part 36 offer under 3611 in writing. But then you've got the Rule 3, haven't you? In the sense of if a procedural rule is not followed, it doesn't invalidate it as a matter of course.
Yeah, so I think that it's, on my analysis, it's a Part 36 offer. As part of that Part 36 offer, the consequences flow. And when you it depends on the exact terms of the acceptance, of course. But when you accept that, then you accept all the consequences that flow, I think. But actually, I've never seen that happen in real life, if I put it that way. I know it's happening in your real life, but it's never happened to me. So I don't think either of us knows the definitive answer, unless Rob's about to tell me. And I think we have a slightly different contractual construction. It depends on the exact terms of the purported acceptance. Let me answer 2 more questions before we start. Does anyone have any views on whether Part 20 claims are subject to quox in clin neg cases? I'm going to answer that one later with reference to a slightly different case. So I will answer that, but just a little bit earlier on. We will answer that a little bit earlier, a little bit later on. Right, third question. The claimant intends to make a Part 36 proposal to the respondent in appeal proceedings. What happens to costs incurred prior to the appeal? Rob, I think that's one for you.
Go on, sorry, I wasn't listening, so I was still listening about
You're still thinking about the other one, aren't you? Okay. Claimant intends to make a Part 36 proposal to the respondent in appeal proceedings. What happens to costs incurred prior to the appeal? I suppose what you would do is if you were making the offer, you would specify, because you can specify in a Part 36 offer that it only relates to a issue or a stage. So you could specify in your Part 36 offer that it only relates to the costs in the appeal. That would be the answer, I suspect.
Yes, because
the others a bit large.
Still, if you make it generally, and then the thing is, if there's an appeal, it depends if it's an appeal against an interim hearing or an appeal against a final decision. So if there's a final decision, there's nothing to be done on the case pending the pay for the appeal. So by nature, if you're making a Part 36 offer, it would incorporate all costs that ran thereafter. Whereas if it was an interim appeal against an interim order, your Part 36 offer either would relate to the whole of the claim, and therefore it would encompass all, or it relates to the issue and appeal, and therefore, by implication, it would go to only the matters related to the appeal.
Yeah, and you can express that in the form.
Jumping back.
One more question. I'm going to answer one more question, and then we must start, otherwise we're never going to get started.
In Rule 3.10, where there's been an error of procedure, such as a failure to comply with a rule or practice direction, the error does not invalidate any step taken in the proceedings unless the court so orders. Well, if you orally accepted the Part 36 offer, you're in breach of the fact it should be written, but does that invalidate the step because you've not done it quite rightly? I think there's difficulty in saying it invalidates it, and the court can then order you to remedy the error by putting it in writing.
Yeah, and there is actually a slide on this later. So we do actually address this to some extent later. Nigel asked a good question. Tactics for a claimant when defendant makes pre-med report Part 36 offer. We were talking about this the other day, actually, Rob. Making it difficult to assess. Can you mitigate the risk? Yeah, and we were talking about this the other day and deciding not very readily, actually.
I will come on and talk about this because there's been a recent decision of Master McLeod, and it's in APIL. For those of you who read APIL, Laura Hibbard of 9 Goff's written an article on that very point, where effectively a Part 36 offer wasn't accepted by reason of uncertainty of prognosis, and then it was accepted later, and the uncertainty of prognosis earlier did not provide a get-out-of-jail card against the Part 36 consequences. Now, there's things to be said about that, but that's, he pays your money, he takes your choice. I think that's the point. So I think there's a pre-med offer from the defendants means you need to do a best guess and probably try and get some medical reports pretty quickly before anyone runs up too many costs. Yeah,
I think that's right. And Master McLeod is generally pretty sympathetic, I think, to people who find themselves in a difficult position, and the fact that it was Master McLeod who made that decision sort of tends to indicate that some of the harsher masters would have done the same. So you're looking, I think you're looking at a really difficult position there. Right, let's get started before anyone else said anything else. As I say, I'm going to be dealing with form and structure, so I'm going to go through that relatively quickly, but some of these questions that you've asked will be encompassed in that. When should you think about making an offer? And this we've touched on really briefly in relation to the answer that we've just given to that question. If you are a defendant, you might want to think about taking a punt early doors, especially if you've got a claimant who suffers from something which looks as if it might turn into something in the nature of chronic pain, one of those somatoform disorders, or something of that nature, which can be completely catastrophic. And we've all had cases where both claimants and for defendants, where you feel in your bones that it's starting small and it's going to get larger. If you act for a defendant, you might want to just buy off that risk. It's actually quite difficult to persuade clients to do that, because they'll say, well, look, we don't know yet that risk is going to eventuate, but it's going to be a lot cheaper to buy it off pre-proceedings than it would be later on. If you act for a claimant, conversely, if you're going to make a Part 36 offer, the client needs to know they're going to be bound by that. I have a client at the moment who is going to undergo surgery quite soon, and the surgery has a good chance of working, but if it doesn't work, she'll need her leg amputated. And that is obviously going to increase the value of her claim massively. Now would not be a great time for me to make a Part 36 offer, because I'm not going to be able to factor in all of the consequences of the leg being amputated. So it depends which side you're working for. I always think personally that if you act for a claimant, you want to leave it a little bit until you've got conclusion of the expert evidence. If you're for a defendant, you want to think about making quite a competitive Part 36 offer as soon as you possibly can, particularly when you've got the operation of quotes, because of course all of those costs up until when you make that offer are going to be irrecoverable. So it's a real problem. I tend to quite like making a Part 36 offer with either particularly the claim or the defence, because then the other side know what you're saying in the pleadings, and they also know what you're saying about quantum, if such is the offer that you're making. Shortly before trial is the least attractive option, but also the one that most people seem to go for reasons that I don't completely understand, because by that point you've incurred all your costs. Now, yes, right, so Chris Deacon is saying in relation to the amputation risk, could offer provisional damages in order to take account of the amputation risk. Yeah, I guess we could do that, actually. Brilliant, thank you, Chris. I'll make a note of that, and that's going to assist with my advice. You're right about that. I tend to forget about provisional damages. It's a terrible thing to say, but it is true. But yes, you're right. There are things that you can do to get around it. Part 36 offers don't really lend themselves very well to that kind of flexibility that call-to-bank offers do. Alec is saying in the Q&A, I've used Part 36 liabilities offers in cases of 90-10% to get Part 36 benefits. Can liability offers be made in cases where contrib is not being alleged or pleaded? Yeah, it can be, but it's hard to see how the cost consequences would follow unless you won completely. But yeah, you can make a portioned offer even when contrib's not being alleged. No reason why you shouldn't do that. Right, let me move on. This is important. Part 36 offer must be in writing, which is what we were discussing earlier when we talked about the acceptance. It must make clear that it is made pursuant to Part 36, so it needs to say on the face of it that it is a Part 36 offer. It needs to specify a period of not less than 21 days for acceptance, and it needs to state whether it relates to the whole of the claim or to part of it, or an issue, and if so, which part or issue. And this is the thing about appeal that we were talking about, and state whether it takes into account any counterclaim. If it doesn't do any of those things, it is by definition not a Part 36 offer, it's a call-to-bank offer. The offer has to be formally served, but failure to serve it in accordance with CPR Part 6 is not fatal. And again, this is what Rob was talking about earlier, the curative powers of CPR Part 3.10, although that case is currently under appeal. And I've put, in answer to a question that we got before this webinar, presumably, similarly, a failure to sign the offer would be similarly remediable, because under the formalities, under Part 36, 11 and so on, it has to be in writing, but it does not have to be signed. So not signing it is, you won't put on the form your signature, but you can remedy that using the analogous situation under 3.10. The offer has to take a certain form, and in order to carry the Part 36 consequences, it has to comply fully with Part 36. And actually this Essex County Council case is quite interesting, because the judge gets quite cross, I think. It's always quite difficult without being able to hear the tape, the transcripts. But the judge says, well, much of the difficulty would be avoided if parties would only use Form N242A to make their offers. So if you just used the form, we wouldn't have any of these problems, basically what the judge is saying. It is always safer when you're making a Part 36 offer to use the form, either in offer or acceptance, than it is to do it in some other way. You can do it in a letter, but it's safer to use the form. And this is the kind of thing that gives rise to the problem with the MIB that we were talking about earlier, where they've not used the acceptance form. If the offer purports to impose cost consequences outside Part 36, it's not a valid Part 36 offer. So you can't say, this is a Part 36 offer that I'm making to you, and it will have the following cost consequences, which are not in Part 36. So, for example, you might do that with multiple defendants. It's not going to be a Part 36 offer if it does that. If it excludes interest, it's not going to be a Part 36 offer. And this is something that happens a little bit in my own field in cross-border cases, because Spanish penalty interest can be very, very high. So, for example, if I've got a claim that's got Spanish applicable law, I've got one at the moment where the damages are worth, I don't know, 100,000 euros, and the interest calculation is 50,000 euros. Now, if I were to make an offer which said, well, I will take 80,000 euros, but we'll talk about interest later, that's not a valid Part 36 offer because it doesn't include interest. So that would have to be a call the bank offer in that form. Anonymous question: when serving a robust LOR or defence, there are reasons for waiting to settle. Yeah, that's right, there are. Any tips for the best way of wording this offer? It always feels like you're weakening robust arguments when you're making an offer. Well, you know, we've all seen letters that say you've got no prospect whatsoever of succeeding. We've got a great defence, but for commercial reasons and because of economics, we are prepared to make you this low offer. But be warned, we will not be making any future offers, and we are doing this for economic reasons only. And you will find, when we come to disclosure of witness statements and expert evidence, we are going to beat this offer, and you will be liable for the cost consequences. And we will go for indemnity costs against you because it's unreasonable for you to accept this offer now. You can only do that if you haven't bluffed people previously. So you need to, if you're going to say that, you need to stand by it. You need to be really, really clear that you're going to stand by it if you're going to do. But that's true of any offers, isn't it? But when you say we're not going to make another offer, you really need to, in order to be believed, you need to stand by your offer.
Can I interject there? I was in Shrewsbury County a number of years ago, and the solicitor on the other side had actually been at school with, and we had a nice chat because counsel for the other side were an hour late. And we had a chat about the case and we formed a view. And then counsel the other side stormed in, said hello to his solicitor briefly, looked at me and said, just so you know, we are going to take you to the cleaners. I just said that's very, very interesting. I expect you ought to take instructions from your solicitor because I'm not entirely convinced that's the stance you are taking. And in fairness to him, and I respect counsel the other side for doing this, he didn't go red and he never explained nor apologised later.
Yeah, I mean, I actually think, you know, you sometimes, I mean, I'm off on a tangent now, of course, one of my hobby horses. I actually think that is not a very helpful approach. And I had a joint settlement meeting not that long ago with someone's clinical negligence case, and the chap from the other side came in and he displayed at me like a bird of paradise. My case is great, you're going to lose. And you know, he said to my client, you know, your barrister's wrong about all of this. She's got the law wrong. She's got everything wrong. And the client just smiled at him. And he said to me, why is your client laughing at me? And I said, well, because I told her that was exactly what you were going to say before you came in and said it. And I said to her that if you did, in fact, do that, that she could be pretty confident that I was right about everything. You know, it's just not a great tactic in my view. Right. If you are a claimant and have a claim against 3 separate defendants, is it better to make one full offer to all 3, or divide the sum by 3 and make it to each defendant for their liability only? Now you trespass on something I'm going to talk about in just a minute. So we are going to deal with that. Lots of people asking about multiple defendants. Part 36 offers and acceptances aren't really great for when you've got multiple claimants or defendants. So let me carry on with form just before we come on to multiple defendants. So there is the option of making an offer less than 21 days before trial. If you do that, you don't have to specify the time for acceptance, and the offer may be accepted at any time until the end of trial. It's really, really important you bear that in mind. I had a trial which settled halfway through when we took the other side's offer because the trial was going disastrously badly for us. Now, once it started going disastrously badly, if I'd been acting for the other side, I would have withdrawn the offer. We needed the permission of the court, but we got it. So just bear in mind, if you do make offers less than 21 days before trial, the other side might just slip a post-it note over to the other barrister saying that they accept it halfway through disastrous evidence. The usual Part 36 consequences won't flow unless the court abridges time for acceptance, which is rarely done. And bear in mind particularly in these difficult times, that where the trial is adjourned after the offer's been made, the offerer has to apply for abridgment, or the offer won't carry Part 36 consequences. But it's safer to make a further offer. So where you have one of those cases where you've made an offer just before trial, trial's been adjourned as they so often are, you need to go back and think about your Part 36 stance and reoffer would be my advice. So, all right, let me just turn that off. So mistake. This is quite an interesting area. Oh, sorry, if I stop screen share, I have, haven't I? That's because I'm mucking about doing answers as well. Part 36. There we go. Let me. I really ought to stop. There we go. On current slide. I really ought to stop trying to do that because it gets me in a pickle. There we are. Right, now, mistake. Part 36 is a self-contained code, which I always thought meant that the normal rules on common law mistake would not apply. So it's not an offer and acceptance type situation. So Gibbon and Manchester says. But Master Dagnall in O'Grady said that the doctrine of common law mistake does apply. So that where a clear and obvious mistake has been made and the offeree is aware of it, there is no settlement, which I think actually sits in quite an odd way with the Gibbon case, because it means that the common law doctrine of mistake does apply. So that does impinge on the self-contained code, I think. But it's good news for claimants, because in that case, the claimant offers to settle a claim on an 80-20 apportionment in the defendant's favour, but it didn't really mean that. It meant on the claimant's favour. And when the defendant accepted that, you know, you can imagine the response from the defendant, hooray, you know, we're only paying 20%. They were allowed to reverse the apportionment and they were allowed to withdraw the offer. I'm actually slightly uneasy about O'Grady. I don't think it's right, but there it is. For what it's worth, it's out there if you can make a mistake. Now, multiple defendants, we've been asked about a bit, and just a question just now as well. Generally, where cause of action overlap, it's appropriate for separate identical offers to be made. So you make offers against all defendants at the same time, but you do need to think about the consequences of that in relation to costs. So you need to make it absolutely crystal clear to the defendants what it is that you are offering them and what the consequences will be in relation to costs. The Re-IT Protect case, quite a recent case, quite interesting, where a Part 36 offer is made jointly and not severally to both defendants in a multiple defendant case, and the claimant succeeds against one but not the other, it's uncertain whether Part 36 consequences will flow. Well, thank you very much, but it would be unjust for them to do so in any event. So Part 36 consequences will not flow, or will probably not flow from such an offer. Now, what was it that Andreas was asking? If you're a claimant and have a claim against 3 separate defendants, is it better to make one full offer to all 3 or divide the sum by 3? The problem with dividing the sum by 3 is that if you, I guess it's a bird in the hand is worth 2 in the bush, isn't it? But you might end up with only one of them accepting it, in which case you've only got a third. You've missed out on your chance to get the remaining 2/3 from that particular defendant. A lot's going to depend on the facts of your case and how strong your case is against all 3 defendants. But you might find yourself in a situation where you only end up with a third of the damages and having to pay the cost of the other 2 defendants. I myself think, I don't know about you, Rob, but I myself think that when you've got multiple defendants, it's better not to make Part 36 offers at all. It's better to make Calderbanks because it's easier to be flexible about those. But I don't know if you have a contrary view.
I wouldn't push against that. I think the point is that if you keep all 3 in the ring, you let them fight it amongst themselves as to contribution. Yeah, well, precisely. You've got a better chance if you've got more defendants, is I think where I go with it, where I end up with that. Okay, Rob, over to you. The consequences. Right, here we go. Brucey's bonus. First things first, if the offer isn't accepted within the relevant period, if it's a defendant offer and the offer isn't beaten, or the words used in CPR 36.17 is the claimant fails to obtain a judgment more advantageous than the defendant's offer, or if it's a claimant's offer, the wording is at least as advantageous to the claimant as the claimant's offer, you get your costs under Part 36 from the date on which the relevant period expired. Relevant period is defined as the period for acceptance specified in the offer, but it must not be less than 21 days after the offer was made. unless, of course, you make it within 21 days of trial. Clear so far. Relevant period, it's got to be open for at least 3 weeks, can be longer than that. Thereafter, the other side gets their costs, the winning side. Now, you'll probably remember there was an argument a few years ago as to what more advantageous meant. But CPR 3617(2) makes clear that it is better in money terms by any amount, and in case you're uncertain, it says by any amount, however small. So for those of you like me, like to watch people cycling around France for 3 weeks at this time of year every year, photo finishes matter. No matter how close the finish, a win is a win. Second place is first loser, if only by half a wheel. So that's the first point. Second point is stay of proceedings, obviously, until the matters of Part 36 consequences are sorted out. Here's the difference. If it's a defendant's offer, 36.17(3)(b), the defendant is entitled to costs if the claimant fails to beat the offer, and those costs will be on a standard basis plus interest on costs unless the case is out of the norm. What does out of the norm mean? Well, you've got the Excelsior case there, a Court of Appeal. It was wrong to order indemnity costs in the defendant's favour on that case, solely on the basis that the claimant hadn't beaten the offer. So just because as a claimant you fall short, that shouldn't be sufficient reason on its own for the defendant to say, you pay our costs, and you pay our costs not on the standard basis, but the indemnity basis. But the case of Excelsior is interesting readings. In that case, the claimant's case had always been speculative, and the claimant had behaved unreasonably in failing to take up defendant's various attempts to resolve the dispute. So they said that unreasonable was actually rejecting the Part 36 offer when you had a rubbish case. Another case is Balmoral against Borealis. It was a resounding defeat, it was said in that case, did not merit indemnity costs, but there were certain deficiencies exposed in the claimant's expert evidence that revealed a technical weakness in their case, so that took it out of the norm. It's almost a two-edged or double-tongued. So if you get thumped, that's not enough, but if you get thumped for good reason, that is. And again, there's a Burgess case of 2020 which said that the claimant's claim was found to be speculative and weak, meaning that it had unreasonably failed to accept the defendant's offer. So, out of the norm means something more than a loss, something more than a resounding loss. It must be something particularly shonky about your case. So that's that. What about claimant's offer? Well, 36.17(4), claimant's entitled to 10% interest on damages, indemnity costs, 10% or up to 10% interest on costs, and the Brucey bonus of 10% on damages up to £500,000, 5% on damages beyond £500,000, up to a maximum of £75,000. So the cost consequences, as you probably well know, are different for claimant and defendant, and actually they're more onerous against a defendant than they are against a claimant. Can I have the next slide, please? Is that all right?
You can, but let me ask you some questions first, Rob, as we're piling up questions. How does more advantageous apply to non-monetary awards like injunctions?
That's a good question. Beauty is in the eye of the beholder, isn't it? And I think that is the difficulty of that. It will depend on, one, how clearly defined your offer is, and two, how well you can then marry up with what is achieved to see whether it's better or worse. But you're absolutely right. Scope for argument there, isn't there?
If Part 36 is a self-contained set of rules, does it still interact with CPR 4414? That can a defendant enforce their costs on late acceptance in a fixed cost case, even though no order for payment of damages? The answer, yeah, okay, we are going to partly answer that later with the case, unless you want to answer it now, Rob.
Well, if it's a Quox case, a damages order bites against, a cost order of the defendant bites against the damages ordered to the claimant, doesn't it? Unless that's a normal rule.
What happens if a second Part 36 offer is made when the first offer made months ago was not withdrawn? They sit alongside one another. You can accept either. You can accept either or, and whichever it is that's most advantageous, that's the one that you're going to be looking at when you're looking at the consequences. Sorry, I answered it by accident. The form states the defendant will be liable for the claimant's costs in accordance with Rule 36.13. For PI fixed fee cases, it's actually 3620 that applies. Given recent cost decisions about contracting out of fixed costs, which we're going to talk about in a moment, is there an argument to be had about summary costs applying where the form is used? Or does 3613.3, except where recoverable costs are fixed by the rules, mean the form mentioning 3613 be irrelevant to what costs are recoverable? That's to do with interaction of Part 36 costs and fixed costs. So Part 36 costs are going to be fixed costs, I think. So the costs recoverable under Part 36 will then be the fixed costs, is my understanding of it, unless you understand something different, Rob.
Got to be honest, I don't do that many touch fixed costs for some time, so I'm terribly sorry to give that sort of underground answer, but...
Okay, let us move on. Sorry, you were saying.
Right. Consequences under Part 3617 will be imposed unless it is unjust to do so, or unless the court considers it unjust to do so. So you've got the 5 factors there: the terms of the offer, the stage of proceedings, the information available at the time the offer was made, the conduct of the parties, and whether the offer was a genuine attempt to settle proceedings. So it's the party at risk of the costs order who have to satisfy the court that it would be unjust for the normal Part 36 cost consequences to be applied. So in arguing the point, the words of Sir David Eadie in the case of Downing, which is a 2014 High Court case, are to be remembered, and it says this: "It is elementary that a judge who's asked to depart from the norm on the ground that it would be unjust not to do so should not be tempted to make an exception merely because he or she thinks the regime itself harsh or unjust. There must be something about the particular circumstances of the case which takes it out of the norm." So the fact that Part 36 cost consequences are tough is tough. That's not unjust. Or another one, Mr. Justice Briggs in the case of Smith from 2012 approved. He said the burden on a claimant who has failed to beat the defendant's Part 36 offer to show injustice is a formidable obstacle to the obtaining of a different costs order. If that were not so, then the salutary purpose of Part 36 in promoting compromise and the avoidance of an unnecessary expenditure of costs and court time would be undermined. The point is that Part 36 is not so much a carrot in reality as a stick. Because if it goes wrong, it will go very wrong. And you've got the recent decision, the McLeod's decision of MRA against the Education Fellowship. And as I said, that was late acceptance of the offer. But the court accepted the defendant's argument that the court should follow its head, not its heart. Cue mood music for a reflective moment. But effectively, the fact that there was a late understanding of prognosis and at the time the offer made, prognosis wasn't known, doesn't matter. That's not what Part 36 is concerned about. And I think that's got to be right, because if the court start going behind the cost consequences too readily, the teeth of Part 36 are effectively removed, or at least significantly blunted.
Yeah, we were asked about genuine attempt to settle. So where you've got someone, say a claimant has always been looking for £100,000 and they make an offer to accept £100,000, is that a genuine attempt to settle, or is it just restating your open position? Because there's case law on this about, where you make a 99% offer. What's your view on that?
On my next slide, so if you want to go to the next slide, I'll come to that. So it's absolutely timely. You're anticipating it well. So let's look at those factors. The first couple of factors to think about are information available when the offer was made and the conduct of the parties with regard to giving of or refusal to give information. Now you've got the case of Head, which is a mesothelioma case. Interesting case. It started off as a lost years case, effectively. The gentleman then died. It was appealed. Part of the decision then was then sent back down to the High Court. It remained obviously a lost years case, but obviously brought by the estate. Now, at the end of all that, the claimant beat his own Part 36 offer. The offer was £2,249,705.80. Can we please just make Part 36 offers in round terms, just as a general plea in life? Anyway, they beat it by 372,000 quid. So obviously, they were entitled to the full lot of the consequences under 36, including the Wolfie bonus of the 75,000 quid, being the bonus on the damages, unless it was unjust for the court to do so. And what the defendant says is that the claimant has adduced evidence very, very late. In fact, after the first trial, before appeal, further evidence was adduced that could have been adduced earlier. Now, Mr. Justice Johnson then heard it when it was sent back down to the High Court, and that the defendant had been prejudiced by the late introduction of that evidence, and in those circumstances it would be unjust for the claimant to benefit from the Wolf v bonus and the full cost consequences, which were only available because the claimant had been permitted to rely on this late disclosed evidence when it was served late without good reason. Justice Johnson said this: the fact that orders under CPR 3617(4), claimant cost consequences, might result in the defendant paying and the claimant receiving considerably more than the amount required to compensate for the losses sustained does not render such orders unjust. That consequence is inherent in a scheme which provides a system of sanctions and rewards as to encourage dispute resolution. It is necessary to recognise that it is the intended purpose of the scheme and to assess in that context whether the making of Part 36 orders would be unjust, having regard to all the circumstances. Again, he says it's a formidable obstacle to show that the imposition of a Part 36 order would be unjust. Now, little points to bear in mind here, schoolmarm point. Mr. Justice Johnson goes on to talk about the conduct arguments that were raised, and he says this: each of the parties advances a litany of complaints about the conduct of the other. We've all been there, put on the whiny voice as you read the letters. Subject to the late admission of the evidence, I do not consider that these points show it would be unjust for the cost consequences. There you have it. The judge wants to hear about conduct, but it doesn't want to hear too whiny a point. It's got to be proper conduct. I think circumstances in that case are going to be rare to arise, aren't they? But it's worth bearing that in mind. Evidence adduced late prior to trial, I suspect the court wouldn't be as sympathetic, so you've had a chance to look at it before you go to trial. And then as to evidence of conduct, don't be moaning, because the court are going to require some pretty clear conduct before they're going to get to him. Now, on to the question, genuine attempt. You got the case of JMX there, and there the court held that a 90% offer to settle was a genuine attempt to settle the proceedings. The court noting that an argument that an assessment of risks of litigation at only 10% could not be a genuine attempt to settle, and that sort of argument could hardly ever succeed, they said. Mr. Justice Fostergate said this: whilst it would be unwise to say never, I do consider this kind of argument to be one which could hardly ever succeed. How one side perceives the risks in a piece of litigation, whether in the clinical negligence sphere or any other sphere, will almost invariably be different from the way the other side perceives them. Quite often in my experience, as a practitioner and more particularly as a mediator, a settlement of a case was achieved when there were widely differing views of the risks on both sides. When offer to accept 90% is made in a case such as this, I would regard it as a case where the claimant's team regard the claim as very strong, but is prepared to offer a modest discount to secure absolute certainty of obtaining substantial compensation. In my capacity as a judge in charge of the Queen's Bench Division Civil List, I see a great many settlements in this area of litigation. When I'm asked to approve the settlement, I've not, of course, kept any kind of record, but my perception is that a wide variety of percentage settlements on liability causation are agreed and approved by the court, including 90% settlements from time to time. Get this, here we go. I can certainly recall several in my own practice in my last few years at the bar. As I said, if I were to accede to the defendant's submissions, I can see that no one will ever offer to accept 90%. The claim is correct that 10% is not a token discount, particularly at a time when the level of damages in a serious case is very significant. It's a genuine offer. And I think that, what if you make a 100% offer? Can the defendant say, well, that wasn't a genuine attempt to settle? Well, the difficulty the defendant's got on that is that you've won. So you were. But I don't quite know what the court would say. 99% would be a different argument because you are presiding some sort of discount. 100% you're not. But I think you look at the clear terms of it, more advantageous. You've made the offer, you wanted the full amount, and that's genuinely what you wanted. You've gone to trial and you've got it.
Yeah. I tend to agree with you, what it's worth.
Now, coming back to the telling tales out of school, the conduct point, Foskett makes some comments about that as well, because what he said is, I should add in the written submissions from both sides, I was told a good deal about the position taken by each side in negotiations or meetings that took place. Namely, they were so unreasonable at JSM and the biscuits were. He said, I did not find what I was told about what was said and by whom to be of any value at all. And for my part, would think that in most cases it would not assist in deciding whether an offer was a genuine offer of settlement. So just be careful again, don't go telling tales out of school unless you've got a good point. Right, third case on that, cost consequences, is Wormald. Let me just give you the facts and you'll understand a bit more. This is a road traffic accident in August 2009. The claimant was very, very badly injured. 5 years later, September 14, liability was resolved 60-40 in the claimant's favour. In 2014, the defendant offered 2 million quid and the claimant said no and rejected it. Later, the claimant's health became critical. 6 years later, in fact, and on advice, they accepted that offer. Now, here's the timing. The offer was accepted on the 18th of September 2020 at 8:09. At 7:30 that day, the claimant died. So, all you had to do then is you had to have the settlement approved. But the defendant said, look, because of the untimely death of the claimant, he didn't need those future damages for care and such like. And so if the acceptance was permitted to stand, the claimant's estate would receive a windfall. And what was held, interestingly, is the litigation friend hadn't behaved in an opportunistic manner. There'd been a downturn in health and they'd accepted an offer that was on the table. But there was a disparity of knowledge. The claimant's team knew that the claimant was in problems health-wise. The defendant's team didn't. Had the claimant pulled through, the claimant could have argued it would be unjust to hold them to the settlement because their case would have been worth more than the 2 million quid. And so in the same way, it's unjust to hold the defendant to the settlement, so the offer could be withdrawn. The obvious point about that is, though, no acceptance of a Part 36 offer in respect of a protected party is binding until you've got court approval.
Yeah.
It's of limited relevance, but it is of interest, that point.
Yeah, I don't love that, but anyway.
Let's move on. Let's keep going. Let's take a...
Now listen, Rob, I'm going to have to leave for one moment because I can see my cat has got herself stuck on... I'm just going to leave for a moment, okay? I'm going to rescue the cat. But I am still listening, I promise you.
Fine, no, you carry on. Right, next slide, Ho. This is the interplay between costs orders and the Quox regime. And what this case effectively shows is that under the Quox regime, you set off pears against apples. Let me explain. In that case, the claimant settled her case for 30,000 quid. Fixed costs amounted to about 16,000 quid. The defendant said it had a cost order against the claimant worth about £48,000. So what the defendant wanted to do was wanted to set off their £48,000 against the claimant's £16,000 cost order, which leaves you with a £32,000 cost order outstanding, and then set that £32,000 off against the claimant's damages of £30,000. Now, what the court effectively said is, no, you can't do that. You can't do a set-off between... Hello, what's the cat called?
Maggie. Margaret when I'm cross with her. Sorry, carry on, Rob.
Great name for Chambers, Maggie Chambers. Anyway, so set off the one against the other. The court said, no, you cannot do that. You can set off the defendant damages only against the defendant costs order only against the claimant's order for damages. You can't, first of all, knock off the respective cost orders going one way or the other. That's the headline. Let me break it down. Judgment said Quox regime did not prevent a trial judge from making a single one-way cost order as a result of an adjustment, and the Quox did not operate a total ban in set-off of opposing cost orders. It merely imposed a monetary cap. But he said Quox was intended to be a complete code about what the defendants in a personal injury case could do with cost orders obtained against the claimant. And the cap under the Quox regime was the monetary value of any set-off by defendant. Effectively, the defendant's costs have to bear against the claimant's damages. So you can't aggregate the cost orders, first of all, and then bite against the claimant's damages. Now, amusingly, Lord Briggs and Lady Rose, the Supreme Court, they said in the closing parts of their judgment, no one has claimed that the Quox scheme is perfect. Word. Not a true word. Right, let's move on from that. That's Ho. Let's go on to the next slide. Right. Sometimes you may not want to make a Part 36 offer. You've got the obvious ones there. If you're after an interim order, when you want something other than money, if trial is imminent, or flexibility, or fundamental dishonesty. Let me frame it in a slightly different way. Sometimes you may want to have different terms regarding withdrawal of the offer. So you make a Part 36 offer, it's on the table for 21 days. If you don't want it to be on the table for 21 days, you'll need to make a call to bank. Sometimes you may want to make a call to bank, so you want different terms as to costs other than the Part 36 terms. One example is when you think the other side's case, particularly if you're a defendant, you think the claimant's case is very, very weak. You may want to make a call to bank offer so that then if the claimant accepts it, they don't automatically get all of their Part 36 consequences of the costs. You may want to be a bit more competitive than that on the costs. Another way is where you want to make an offer with different terms as to payment. Maybe you can't pay the full amount within 14 days. Maybe you can only pay it by way of instalment. Sometimes you may want to make a call to bank offer where not all of the terms can be nailed down, but you want to effectively settle subject to contract. So you make a call to bank offer in sort of all the terms, and then you nail down the issues thereafter. One interesting point is if a call to bank offer is made against you, say for 50,000 quid, and you suddenly think 50,000 quid is quite a good settlement, what do you do? Well, one answer is, well, why not offer back 50,000 quid by way of Part 36? Arguably, that would be a rejection of the call to bank offer. But if the defendant is willing to settle, the claimant's willing to settle for 50,000 quid, the client will get their money, and then there's a different cost consequence to apply. And then I think it's worth thinking who will be the paymaster. Because if it's an insurance company, there may be more flex. If it's privately paying, it may not. But anyway, that's just a side point.
Yeah, I like that.
So, Part 36 is generally route one, isn't it? I've got to be honest, as a claimant counsel, I'm generally less interested in call to bank offers, and I'm very much not interested in combined damages cost offers. That's the initial reaction I have. Part 36 is far easier to see, but there are good reasons why you wouldn't always do it. Or I see the force in, and I had one the other week where I had a Part 36 offer and I had a call to bank of 15% more that was available for the next 2 weeks and 2 weeks only. Yeah. I see that, but it doesn't make me massively interested, to be honest, because if I know you're willing to go for the higher amount, I will advise the client against that. But the cost consequences of a 2-week offer, I feel relatively confident at resisting later down the line would be more the cost consequences of the Part 36 that would interest me.
Yeah, it doesn't put you under as much pressure on costs, but if you know you've got a problem on damages, then you might want to grab it. I quite like those defendants, actually, if in the right case.
Okay. Next slide. I think we're there, aren't we, on the slides?
Practically. This one is the Doyle case, which is a, be really careful about this. This is a consent order, it's not a Part 36 offer. The parties agreed in a consent order that costs would be subject to detailed assessment, which took the claim out of the fixed cost regime, and it meant that the defendant, by agreeing to that, they became liable to pay the claimant's costs on the standard basis, not on the fixed cost regime, which is something of a catastrophe as far as the defendant's concerned. Now, I myself don't particularly see why the common law rules on mistake shouldn't come to the defendant's rescue on that, because both parties must have known that was a mistake. So I'm not quite sure why O'Grady doesn't work there, but it doesn't work. And that's the Doyle case. That's quite a recent one. Just a word on RTSM or JSM. When do you have them? It's the old argument we're talking about with Part 36 offers. At what stage do you have them early? Do you have them late? I myself like them somewhere in between. So after you've had joint statements from the experts, generally speaking, although there can be some advantage to having them before joint statements from the experts. depending on how confident you are in your expert. I mean, that's going to depend a lot on what's come out of your conference with your experts. And just a note that I was talking to Rob about this the other day, about having RTSMs, getting a look at the other side, getting a feel for their confidence in their case, and then making an offer after the RTSM or JSM, because it is a mistake to think that you have to settle on that day. I know we all get very excited, clients there, you've all geared yourselves up to settle on that day. It doesn't have to happen that way. There is actually one person at the bar who always, invariably acting for defendants, makes a very low offer at a JSM and refuses to budge on it. And you, for the claimant, say, well, okay, I'm walking away from this. And either when you're on your way home or the following day, his solicitors will make an offer which is higher, notwithstanding that he said that was his lowest offer at JSM. Once you understand that about that person, that's fine. It just means you go to the JSM, he makes your offer, you say no, you tell him what you're prepared to take, you walk away, and the following day you get your offer. I myself don't totally understand that as a tactic, but it is possible to make offers after the RTSM or JSM, whatever it may be. Now, have we reached? Yes, we have reached 1 o'clock, which can mean only one thing. I need to tell you about the next webinar that we'll be doing, and it'll be a totally one Chancery Lane one on that occasion. It's holiday claim one. We have got lots of questions still to be answered, Rob, if you're happy to continue answering questions. Okay, don't feel you must stay all, but we are answering questions now, just as and when they come. So first one from an anonymous attendee. On your previous points, the issue on specifying hourly rate costs or CPR 3620 was addressed by the Court of Appeal and Ho. If you want to offer fixed costs, you should specify 3620. Yes, we've now discussed that. Can you give an example of when information available at the time the offer was made will make it unjust for the court to impose consequences? I mean, a good example of that I've had is where the other side knows something. For example, they know that their expert has rowed back on their opinion, and they don't tell you that before making the Part 36 offer. If that subsequently comes to light, it's going to be unjust for the court to impose consequences because they knew it, they should have told you, but they did not tell you. Or, for example, where disclosure comes to light, which they do not disclose until after the Part 36 offer is made. That seems like a terribly clever wheeze at the time, but actually isn't necessarily if it's going to come to light, and notwithstanding being completely unethical at the same time. But that would be unjust. Where the other side's behaved unethically, for example, then it would make it unjust for the court to impose consequences, I think. One for you, Rob. Can you make a Part 36 offer of no pounds? I will offer you no money.
Well, we have to write into that if you're a defendant, obviously.
Yeah.
Well, it's the same as can you make a 100% offer, isn't it?
Yeah.
And
Yes.
I see the point coming in that a 99% offer, according to, I forget the gentleman who sent that in, has been rejected. Is it genuine or is it not? It will depend on the precise circumstances. In one sense, as a defendant, though, you're going to get your costs on a standard basis anyway. So actually, your loss is not that great. And what's the point, in a sense? Why not?
Yeah, it doesn't help you actually, unless it's out of the norm. So it's only on a standard basis one way or the other.
If it's quacks, you can only enforce your cost order against the damages.
Yeah, well, yeah, that's true. And actually, the combination of quacks and Part 36 actually really disadvantages defendants.
Yeah.
It's very much more advantageous to claimants. Going back to liability offers, what are the cost consequences of one defendant accepting a Part 36 offer against another defendant? What are the cost consequences for one defendant? You've got two defendants, claimants made Part 36 offers, one defendant accepts them and the other one doesn't. What's going to happen then? Does the claimant pay the defendant's costs of discontinuing against them? Or does the claimant, because the claimant then has no claim against the other defendant?
Well, it's the Sanders and Bullock order arguments, isn't it? You fall into that line.
Yeah, it is. So you would try and get your costs against the other one, against the one against whom you've succeeded. But it would be as well to be clear about that when you're making the offer. Where quacks applies, where you can't offset costs against costs, Can the defendant deduct their costs from damages where the acceptance is prior to trial? I think you've now answered that in the Ho case. Am I right about that?
I don't quite understand the question. If it's prior to trial, how can the defendant deduct if the costs order the defendant gets against any damages? Because there is no order for damages until you get to trial.
Yeah, which is the Ho case.
Yeah.
I understand. I was out rescuing the cat at the time, but please can you remind me the name of the case where uncertainty of prognosis was not a defence for the Part 36 consequences?
Yes, it's MRA, isn't it? I'll give you the precise reference here. 1 second.
Thanks, Rob.
Face ID. Bear with it.
Yep, you carry on.
Against the Education Fellowship, 2022, EWHCQB. I haven't got the precise number, sorry. Master McLeod.
Super. Just going back through the chats. What the initials on the slide for. So JSM is joint settlement meeting and RTSM is round table settlement meeting. Sorry, I should have explained that. Yeah, 99% you did. Does a drop hands offer apply the same way? Sorry, I don't know what you're talking about now because that was at the time. Drop hands offers, would that be a Part 36 offer, off to drop hands?
Well, it depends on how it's phrased, but again, it's a 0% offer, isn't it?
Yeah. Right, any other questions, put them in the Q&A because I can't go back through the chat because there's so much of it. If a Part 20 claimant discontinues their claim against a Part 20 defendant, can the cost be pursued by the Part 20 defendant? If you're talking about a PI case, like a standard PI case where the claim is for personal injury, they claim against the defendant and the defendant then pursues somebody else. So I mean, the case that gives rise to the leading case in this is actually a travel one. So it's a skiing case. Claimant goes off skiing, brings a claim against the tour operator. The tour operator then brings a Part 20 claim against the ski instructor. The claim failed. So for that reason, there was no claim by the Part 20 claimant, but it's the same idea. The Part 20 claimant, if they discontinue their claim against the Part 20 defendant, that claim is not a PI claim, so Quox doesn't apply. So it means that the Part 20 claimant then would have to pay the Part 20 defendant's costs, which seems unfair, actually, because the Part 20 defendant has won because there is no claim against it, but it has lost Part 20 claim. So yes, in that situation, costs can be pursued by the Part 20 defendant and they would be costs against the Part 20 claimant because Quox does not protect a Part 20 claimant in those circumstances because their claim is for a contribution or indemnity. It's not a personal injury claim. Right, I think we have answered all the questions that I can possibly imagine could ever be asked about Part 36. If anything else occurs to you, and I can't believe I'm saying this, but if anything else should occur to you about anything that we've said, then please do feel free to drop us a line. Any knotty problems hopefully resolved by one or other or both of us. You will, as I said, get the slides to this. It will be on YouTube if you want to circulate to the rest of the teams. It's been lovely to see you all and hear so many great and engaging questions. There's still, I think, quite a lot of uncertainty about Part 36, notwithstanding the fact it's been around for so long. Lovely to see you, Rob.
Nice to see you too. Enjoying the colour of the wall.
Well, I'm enjoying your art. So, you know, I can't wait to come up to the conference rooms. There is a rooftop terrace in Markov, so, you know, it's pretty swanky up there. And I will see you all soon, and I will stop the share and end the webinar unless anyone has any further questions for us. No, super. Well, have a lovely day all. See you soon, Rob.
Bye-bye.